Okay, well, let me start off. And my name is Brian Nunez. I go by he, him pronouns, and I'm the Senior Policy Associate at the Southern Poverty Law Center. And I pass it to Isabel.
Hey y'all, so I am Isabel Otero, and I am the Georgia Policy Director for the SPLC. It's very good to be with y'all. And I'll pass it to Megan.
Hey y'all, I'm Megan Gordon, she, her, and I'm the Policy Director at CARE Georgia. You also may or may not have noticed the cat right under my screen. Her name is Hermione. I cannot control her, and so she will be showing up during this webinar, and maybe some of the other cats as well. I hope she's not too distracting. I promise the scratching noises of her at the door would be even worse. And I'm going to pass it back to Isabel.
Today we are talking about protest rights. Thank you, Brian. And how to both understand the landscape of what protest rights look like in our state, and also what we can sort of expect from the Georgia legislature as we move forward. Because unfortunately, over the last few years, we have seen several pieces of legislation that have been very particular in attacking certain types of protests. So you'll notice that they don't just want to attack any kind of protest. They're very particular in the kind of protests that happen on the civil rights movement, in sort of civil rights spaces and movement work that we're all familiar with. And they are to criminalize or to sort of suppress and prevent people from using the kind of tactics that we typically see on the side of the folks fighting for civil rights. And so I'm trying to keep this all like C3 and, the way we need to be talking about it, but these increases in the ways that we see in the ways that we see, oh my gosh, why? I'm just going to have one of those nights. Okay, there you go.
So before,
yes.
And Nikki, so I couldn't
I see you now, Nikki.
She wanted to say something before we started, and I put it, yeah. Nikki, did you want to say anything?
You're still muted, Nikki, just so you know.
Okay, well, we can start off then if maybe Nikki wants to say something at the end. So are y'all able to see the presentation on the screen? Perfect.
Yes.
Okay, so go ahead, Isabel.
Yes. So some of the bills that we're going to talk about today are around the expanded domestic terrorism statutes, some critical infrastructure bills, the cash bail bill that passed a couple of years ago, and some of the new proposals around domestic terrorism, material support for terrorism, and we're sort of going to talk about what these things would actually mean in practice. And then CARE Georgia will talk about some of the other ways in which we continue to sort of impact the way people can use their First Amendment rights, especially their freedom of speech, and how all of these sort of taken together are tools that continue to affect protest movements, organizing infrastructure, and the risk that we see for nonprofits, for students, for faith groups, and for movement lawyers. All right, next slide, and I'll kick it to Megan.
Okay, so before we just expanded our domestic terrorism statute in 2017, a lot of protest adjacent incidents were charged for the things that they were alone, vandalism, arson, etc. But now, because we have this law, not new anymore, but if prosecutors allege a political motive plus certain property crimes, they can reframe the conduct as terrorism. So it's no longer, if you do a vandalism with an alleged political motive, they can now frame that as terrorism, which has a much, much higher sentence. Even if the charge is later reduced, you coming in with that terrorism charge increases the leverage that the prosecutors have in plea bargaining, and it really shapes the public narrative, which is a theme we're going to keep talking about today. and it sets the stage for stacking other things like RICO and material support charges in large protest cases. Now, I'm going to pass to Brian.
Thank you. So yeah, I'm not sure a lot of you are familiar with this. This is Senate Bill 63, which limits organizations or individuals to very few bail postings each year and pushes them toward full bail bond company regulation. So as you know, this affects Black and Brown communities the hardest. For protest-related arrests, this can mean longer time in jail. Pre-trial for students, faith leaders, and low-income community members. So it's, once again, just greater dependence, pushing towards a greater dependence on commercial bail. As we know, a federal judge has actually already temporarily blocked part of SB 63 that capped how often nonprofits can post bails, of course, citing free speech, association, and religious liberty concerns, which shows that these restrictions are constitutionally contested. But of course, as we already have heard from the legislator, which was, Senator Randall Robertson, he is interested in bringing back whatever provisions were struck down. So this is relevant to what we're discussing because SB 63 pairs with higher level charges like terrorism and RICO to raise the stakes of simply being arrested at or near a protest or demonstration. And with that, I'll pass it to Isabel.
I think the next one might be Megan, but really quickly, since I have the floor, what I will say too is that we've seen that judges, especially those who are elected judges, are much less likely to even let you have bail in your pretrial processes because they don't want to have to defend having let someone out on bail with a domestic terrorism charge, even though that would have, like Megan said, before 2017 been something like just vandalism or just something else that would not be as politically charged. And then I'll send it to Megan for the critical infrastructure issue.
All right. So again, going on this trend of like prosecutors layering on additional stuff, there's been a trend in the last few years nationwide of adding additional protections for critical infrastructure. This usually sweeps in definitely utilities, sometimes data centers, other logistics hubs, health facilities, transportation centers like highways and more. It's not just government buildings. And so again, because of this, just like we talked about with domestic terrorism, conduct that might have been like simple property damage can now be treated as an attack on critical infrastructure, even if you graffiti or throw a rock at an electric thing or like a data center, a water filtration thing. You can tell I don't know a lot about the infrastructure. Now that is a much higher charge than it would have been before this, but the actual conduct and intent is the same. This is especially relevant to protests that happen near these sites, which gives prosecutors the option to reframe this as a public safety or national security issue because you're protesting a data center or some other type of expansion or even just being nearby. And it also gives them the opportunity to layer on domestic terrorism or infrastructure, like endangering critical infrastructure charges on top of whatever it was that the actual behavior that was done. Now I'm passing it to Isabel.
So one of the things that we do at the legislature, along with all of you, when you're able to come for Justice Day or for other advocacy days, or just in general when you're there, is essentially make this case to legislators that, you already have enough criminal penalties in the law, in the code that exists for you to charge someone with whatever you want to charge them, right? You do not need to continue creating additional crimes. You do not need to create new penalties and new added, enhanced sentencing to actually get at someone who may have committed a crime. And so one of those proposals, unfortunately, that they keep coming back to, and that year after year we kept coming back to them and saying this is not necessary, and not only is it not necessary, it's going to cause a lot of problems, is this idea of a anti-riot bill. And so one of those bills that's currently being moved through the process, which we hope it dies again this year, but is SB 171. And it's called the Safe Communities Act. It has not yet become law. We might see it again. We'll see, right? Like we've managed to like hold this back a few years based on some of our arguments that this is not a helpful way to define a riot, right? Some of the ways in which they have defined riots in this bill before are two people making a ruckus outside of a public establishment. So is that going to be two ladies outside of Planned Parenthood with signs? Can we call that a riot if they start yelling at the people trying to go into the clinic? Or is two people having a bar fight? Is that a riot now, right? Like there are these ways in which just because you want to address an issue, putting it into the law in a very clumsy way, which is how the legislature often does it, is not actually going to solve the problem. And in fact, it's going to cause other ones. And so SB 171 would have turned street blocking into a felony after dispersal order. And we know from a lot of us who have been out in the streets in movement protests, dispersal order, they've already blocked you in, right? Sometimes, like they've already made it difficult for you to disperse. Like there are ways in which you can easily see what the police are planning in order to try to capture and arrest as many people as possible. And if folks who are not used to seeing those things and maybe don't have, this was one of those protests that doesn't have a marshal, doesn't have the legal observers, it just happened sort of spontaneously, you might not have folks around to be able to say like, hey, something bad's about to happen, like we need to get it together. And so the other thing that it would do is increase penalties during unlawful assemblies, right? So anything where you would not have gotten a permit for something. So if, say, there's some other horrible thing that happens and all of a sudden there's a new No Kings protest or some other kind of protest in the streets and there was no permit or anything like that, that could be called a riot under the law, under this bill, and it would have an additional fees and fines and enhanced penalties for anything else that you were charged with. And then there's expanded liability for cities, where one of the things that the state legislature really likes to do is preempt what cities can and cannot do. So sort of like pre-tell a city what they're supposed to be doing. Even if the city has its own police and its own policies about how to address and deal with protesting in order to, not escalate situations, right? And so some of these kind of protest language would affect how a city like Atlanta or somewhere else would actually deal with protesters. And this is not, these are the kind of things where, again, clumsily written laws like this that are trying to address one protest that happened that people didn't like, or a type of protest that they saw where people took to the highway to block it, or whatever else, right? Like they call it a public safety concern. They say something about ambulances and whatever else they want to say, so that they can get away with passing really bad legislation like this that won't actually address either the reason why people are protesting, right, in the first place, or whether or not you can actually charge people who are actually committing crimes with anything that would actually get any justice, which, we can have a theoretical discussion about what that actually would be. And so in this particular case with the riot bill, one of the other problems that we keep pointing out to them is that the case law is so sparse on the issue of what a riot actually means in the law that the last time that this was talked about in the courts was the 1800s, where two people with guns were cahooing in the street, is literally the quote from the judge. Now, I'm not super sure what cahooing means, right? But someone would have to decide what cahooing means today, and have to get that through the court system in using a situation for people with guns outside of somewhere in the 1800s. And that's a crazy nonsense way to decide anything. And it also doesn't provide, any protections for the people that a lot of our legislatures care about, right? So one of the arguments that's been very effective is for us to say, do you really want to say that a riot is two people outside of an establishment carrying guns? Because don't the people in your district sometimes just do that, just like on a regular Tuesday? There's just these ways in which they're not really thinking through the consequences of the legislation that they keep putting forward. And so, even though it has not passed, it telegraphs, it tells us, right, what they're continuing to try to redefine in common protest tactics, and it continues to be an issue that we're going to have to fight against, especially as more protests continue to be organized across the country. So with that, I'll send it back to Brian.
Thank you for that, Isabel. Another bill that we are very concerned, both, us here presenting and a lot of other organizations is, the HB 675, which is the material support for terrorism. Thankfully, it didn't have a lot of traction last year, but we are definitely keeping a close eye just because of how much concerns we have with this bill, specifically when it comes to civil liberties. The language is so broad that it can sweep any type of peaceful activities around controversial movements. And with them, they would pretty much, get to decide what is quote unquote controversial. So anything from legal support to training to mutual aid could be, swept under that, even if there is no violence. The problem with this is that in combination with RICO, prosecutors can argue that protest networks, bail funds, and even support organizations are a part of a criminal enterprise. So we know how dangerous can be in quote-unquote providing support for alleged terrorism. Even, of course, and as legal organizations, we know that even if these theories lose in court, the process itself of arresting, bond conditions, legal costs, and all of that can have very strong chill on organizations and can punish any type of dissent. So this is one of the things that's being very much First Amendment pro organizations. We want to make sure that this is not limited and it's one of those rights that is enshrined and is continuously protected and not one of the many things that we've seen have been slowly deteriorated or chipped at when it comes to the rights of, those that live here. So with that, who is next? I think it might be Megan with the terrorism declarations.
All right. So speaking of terrorism, y'all might have heard that a couple weeks ago, Texas Governor Greg Abbott issued an order declaring CAIR and the Muslim Brotherhood foreign terrorist organizations under Texas state law, which prohibits CAIR National and CAIR Texas from operating or owning land in Texas. Yesterday, Florida Governor Ron DeSantis did something very similar, saying that CAIR and the Muslim Brotherhood are foreign terrorist organizations and that state agencies are directed to undertake all lawful measures to prevent unlawful activities by these organizations. It's like, cool, we're not doing anything unlawful, so fine. But it also says, including denying privileges or resources to anyone providing material support, which is a great callback to what Brian just talked about with material support for terrorism, because that, if they say that we are terrorists, and then, so I should be specific, it's not, this does not impact CAIR Georgia right now, but if they say that CAIR are terrorists, then if you're supporting CAIR, you're providing material support to terrorism under state law. This isn't about law or facts, it's about making baseless allegations to discredit an organization that's saying things the government doesn't like, because it's very obvious. CAIR is not a terrorist organization. We're just a civil rights organization. Our national office has already filed lawsuits against Abbott and DeSantis, arguing that these are illegal on multiple levels I could get into if y'all want those details. But one thing that I want to point out is that while Islamophobia makes Muslims more likely to face terrorism allegations like this tool could be used against anyone. And in many ways, Muslims have been dealing with stuff like this for like 20, 30 years. CAIR has certainly been dealing with stuff like this for most of our history. There's a lot of right-wing conspiracy theories about us. And so if you or your organization are worried about terrorism allegations and things like that, I encourage you to look to the Muslim community, because we are unfortunately kind of experts in this topic. Next slide, please. This one is also me. All right, so here's how this all stacks up in practice. Georgia's RICO law, as we know, is unusually broad and has been used in multiple high-profile contexts, not just protest cases, but of course we're all familiar with the RICO charges brought against the Cop City protesters a couple years ago, which thankfully were recently dropped. So, as Brian just mentioned, what these laws allow them to do is charge dozens of people as part of a criminal enterprise because they all went to the same protest or donated to a bail fund, and to sweep in protest organizers or community organizers and bail fund staff to argue that, like, by bailing people out of jail, you were in a plan the whole time to support them doing crimes and critical infrastructure and domestic terrorism. And we've seen them also layer over like money laundering and charities fraud allegations on top of protest charges to really try to break the infrastructure of movements. Courts have begun to push back on this. As I mentioned, the RICO case against the Cop City protesters was recently dismissed, as well as the charges, the money laundering charges, against the bail fund organizers. But of course, they're still going through this underlying legal strategy of testing RICO and terrorism charges against protest movements. And even partial defeats like this can still tell us a lot about what they have planned. I'm going to toss it to Isabel.
So why does this matter to all of us who are doing work in the civil rights space, who are watching what's happening in the world and may want to be in protest with some of our fellow neighbors? I think the main way to think about this is that this would really, if these laws continue to be passed, if they are upheld by the courts, if they pass some of these new proposals that we've talked about, it would really create quite a structural shift in the way that people are able to exercise their First Amendment rights, right? It's not just that there's this isolated thing about bail over here and there's maybe you shouldn't do this for critical infrastructure. No, it's trying to capture ways in which large and small protests in particular locations and by particular groups are handled by law enforcement and are prosecuted. And so it's important for folks to understand those risks so that as you are deciding whether or not to participate in a protest, you know what the risks are, you know how to prepare if it's going to be an organizational thing where your organization itself may plan something. You need to know and understand the risks for support infrastructure. How will this affect what kind of legal teams you have in place? Is there going to be bail funds? Are nonprofits going to be named? Like, there's different ways in which we all have to start thinking about these things very strategically and thoughtfully so that we do not get, wrangled into some of these, these theoretical ways in which these bills are attempting to be enforced, right? And so we want to make sure that folks understand that big or small, no matter what the subject is for a protest, this is going to impact how you both plan and participate. And I think knowing that for coalitions especially, knowing that the domestic terrorism bill is in place, that the critical infrastructure bill is in place, the bail, the RICO tools that prosecutors use, you need to make sure that you are thinking through how to stress test and scenario plan your legal support, your mutual aid systems, and document how these laws are shaping your planning and shaping your risk conversations so that we can make those arguments as we do legislative advocacy. Because it's important for us to be able to tell those stories from every perspective we can so that it's not just us talking as advocates, but that it's the people coming and saying, hey, I'm going to need you all to stop, trampling over my First Amendment in this way. These are the reasons why I don't think this is helpful. And so I think it's important both for us to just understand the risk and the problems that exist currently in the law, and also for us to be prepared to do some advocacy on this and join us at the Capitol to help fight against some of the new proposals that you see and to try to undo some of the ones that we've already seen pass. And I'll pass it back to Megan.
All right, I want to talk about a bill that was passed last year that seems random, but I promise ties in here. Last year, the General Assembly passed HB 30, which directs state agencies and any government body designed tasked with doing any kind of anti-discrimination work, so this also applies in schools, for example, to adopt the International Holocaust Remembrance Alliance definition of anti-Semitism when enforcing laws and rules that prohibit discrimination. This is problematic for a couple reasons, largely because the IRA definition explicitly defines criticism, some criticism at least, of the State of Israel and of the Zionist movement broadly as inherently anti-Semitic, which supporters of this say that it's going to help agencies recognize modern anti-Semitism, but a broad coalition of civil rights orgs, including Care Georgia, argue that this would allow accusations of anti-Semitism to suppress protected political speech, including advocacy for Palestinian rights or any other criticism of, again, the Israeli government, not Jewish people, but the Israeli government. And it equates anti-Zionism with anti-Semitism in state enforcement, because this law lacks that nuance. This connects to protest and criminalization because agencies and somewhat prosecutors all have this signal that political critiques of Israel can be used as evidence of discriminatory intent, especially when the bill defines critique of Israel as anti-Semitic, because that means that if you are, say, at a protest or protesting remarks by an Israeli government official, for example, that could be construed as inherently anti-Semitic and a violation of HB 30, depending on what you say. And then, of course, this is able to be combined with domestic terrorism, material support, and RICO tools, framing Palestine solidarity organizing as bias-motivated or extremist, as anti-Semitic, as terrorism, rather than as political dissent. And we've already seen that largely happen in, for example, federal narratives around the movement against the genocide in Gaza. Now, these arguments haven't been fully tested in Georgia courts and protest cases, but what we are seeing is that ever since HB 30 was passed, communities are self-censoring to avoid being labeled as anti-Semitic because they're worried about the implications of this law. And we have another similar one, a similar bill moving through the legislature now. Senate Bill 375 was introduced on the last day of the 2025 legislative session, so we're going to pick back up where it left off in 2026. Similar to HB 30, this says that state agencies must consider a definition of Hinduphobia when enforcing anti-discrimination laws, and when judges and stuff are looking at whether a crime was motivated by bias. Supporters say this is about protecting Hindus facing bias and violence, but human rights and free speech advocates, again, including Care Georgia, warn that there are some risks here. For example, there is a really strong Hindu supremacy movement in India that has been imported to the U.S. as more and more people have immigrated here from India. I don't have time right now to get into the nuances of that movement and what it looks like, but this law would allow those movements to treat criticism of Hindu supremacy and criticisms of caste discrimination and even the policies of the Modi government as Hindu-phobic, similar to the way that criticism of Israel can be framed as anti-Semitic under HB 30. This would also force HR offices, universities, local governments, etc., to investigate political speech, like, again, speaking out against Hindu supremacy or Modi or caste discrimination, as if it is simply discrimination and hate towards Hindus as such. What this looks like in a protest context is that organizing around ending caste discrimination or minority rights in India, or the rights of any minority faith in India, or the opposition to Hindu nationalism, is reframed as bias rather than as political critique. And again, similar to HB 30, this can be combined with domestic terrorism, RICO, to argue that movements against Hindu supremacy, against caste discrimination, are extremist or hate-motivated or biased, which essentially slanders those movements and makes that space even more heated. Now, I want to be clear as I wrap up on these last two bills, is that the issue here is not about protecting religious minorities. Protecting religious minorities is fabulous. Again, that is something that we do at CARE. The problem is that both of these bills are drafted very broadly and enforced very selectively so that they become tools to silence dissent against really powerful transnational movements instead of simply being used to protect practitioners of certain faiths. Now I'm going to pass it to Brian.
Thank you for that background, Megan, on those two bills that we are seeing, being already passed and now one that is on the horizon. I think that this is, good background so you could see how they're building and test trying anything to limit protesting and limit our civil rights here in Georgia being a ground zero to it. We see that this is a strategy when it comes to treating any type of movement or solidarity networks as quote-unquote enterprises that are promoting terrorism. This is, turning routine support work that a lot of us do, from bailing, legal referrals, to mutual aid, into any type of criminal activity. And of course, as we have seen, the using quote-unquote money laundering and charities frauds to attack the actual infrastructure that we are seeing from a lot of our partner orgs or other organizations that deal with civil liberties, to just make sure that it is harder to protest pretty much in the state. They want to make sure that if anything that they seem as negative or attacking, the standard that they want to set for Georgia as criminal. So hate definition bills like the ones I make a mention, like HB 30 and SB 75, give the state additional language to argue that certain political movements are not only disruptive but hate motivated. So this is how it's all being set as a foundation that it can build to further limit our First Amendment rights. And the sad thing is that even when judges dismiss the RICO charges, and the prosecutors themselves drop many of the charges that maybe at the beginning were brought up, defendants spend years under indictment, facing employment barriers, travel limitations, and of course massive legal bills. So those are just some of the way how the hate, quote unquote, is being framework to limit our protest rights. And with that, I'll pass it to, I believe it is Isabel.
Nope, it's me.
Oh, sorry.
Sorry, y'all gotta hear from me one more time for key takeaways and strategy. So we have some cause for hope here, right? We've seen the dismissal of the RICO charges and the pause of Senate Bill 63. It shows that resistance works and that these laws or the misuse of laws, is very legally dubious, and that judges are pushing back on that. And the underlying infrastructure here, the legal infrastructure, is still in place. This is really scary content. I hope we haven't freaked everyone out. This is not to panic you. It's about being realistic and prepared so that we can make sure that as we're organizing, we are dotting all of our I's and crossing all of our T's so that we are able to prove to the public and to in court if needed that we are doing our things right. The state has raised the legal stakes for protest organizing, for giving to causes we care about, and also they are attacking our communities even more, so the stakes of this work has never been higher, which is why now is not the time to soften our demands. Our safety is never going to come from the state. It's going to come from building transparent, resilient legal and operational systems and for standing up for each other when the state targets anyone in our networks. This is indeed, I referenced earlier that Muslim communities have been facing things like terrorism charges for 20-something years. And this is the lesson that we've learned, that shrinking away from our work because we're afraid of what the government is going to do to us does nothing for us, does nothing for our work, does nothing for our communities. In fact, all of this is, everything that we've talked about is part of a larger shift into authoritarianism that we're seeing nationally. And experts on democratic backsliding, on movements against authoritarianism in other countries tell us that every time the government does something like this, every time they do an authoritarianism, every time they come for one of us, the most effective way to fight back and to win a stronger democracy back is to push back every single time, to stand in solidarity with the least popular of us, and with other movements, because the tools that they are trying to put in place by attacking the least popular groups, the lowest hanging fruit, will eventually be used against all of us. So our response has to be consistent, strong, unapologetic, and across movements. All right, and now we're handing it to Israel. Isabel, sorry.
You're muted, Isabel.
Thank you. So I was having a coughing fit earlier, so I figured I'd spare all of you from that. So we definitely want to hear your questions if there's something we need to clarify, if there are other issues related to speech that we can talk about. Do remember that Megan is the only lawyer on the call, but also technically we're all here as policy folks, and so if there's a specific scenario question, we might have to take it back to our legal teams to answer. But definitely do want to just echo what Megan said about, as we see attacks on protest, speech, and other civil liberties, we need to be very, very strong and consistent in our pushback, and we need to be thinking about what we want our future to look like, right? Like what is most important for us, and what are we asking each other to fight for? Because I think everybody's pretty tired of the status quo as it was. And is very tired of the situation as it is now. And so thinking through and trying to think about what does a future protest movement look like? What does a future for your free speech and civil liberties look like? And let's see how we can make those things happen. Is also a really important exercise that a lot of us are trying to do more and more. And also just telling your stories is the other thing I would say, is that as, people are out doing this work, it is really important for you to not just tell your story to each other and to the public, but also to those people who currently have power and a vote in their legislature to do something to change the things that we want to change. And so with that, we're going to see if we can get Nikki on. We have her as a panelist now. She wanted to give a few thoughts. Nikki, are you able to unmute yourself?
Can you hear me?
Yes.
Okay. I can't come off camera, but at least you can hear me. I just wanted to thank everyone. Did you all have any questions? So I don't know if anybody had questions in the chat or in the Q&A. Are they able to put questions in the Q&A or in the chat?
I don't see it now, but I think folks should be able to also unmute themselves. But if you have questions while Nikki is speaking, we're happy to take them after as well.
Well, I just wanted to just thank you all, Brian, Megan, and Isabel for just doing this great topic for tonight. This is our final Talk Justice Tuesday of the year. And for those of you who've stuck with us throughout the year, thank you for our supporters. And when we made the shift of doing Talk Justice Tuesday, a monthly webinar, it was a big shift for those in the coalition and folks who are on the call for the first time. Our partnership grew from 5 to well over 90 organizations and individuals in our space, and we love that. And for those of you who are, our supporters, we're so thankful. We can't do this work alone, and we need your voices. We're getting ready to enter into our session the second Monday in January in 2026, and it's going to be tough, but we do this work. We don't do it alone. We do it with our folks who are on this call and who continue to join us throughout the year, and we're so thankful. But I always want to tell folks, take time to take care of yourselves. We're in the holidays. Take some time to take a break and reset. But 2026, we're going to start back up on January 13th. We'll have our legislative session. So our Talk Justice Tuesday, throughout the session, we do focus on our legislative series. So our Talk Justice Tuesdays throughout the session will be legislative topics. So follow us on our website. We do not have our registration set up yet, but we will. So our first one will be January 13th at 6 o'clock. We're going to have them in the evenings. So our legislative advocacy one-on-one training, our registration will be open shortly. So just follow us on our website to register for that Talk Justice Tuesday. But I just want to thank our panelists, though, just for this topic, ending us this year on, this topic that's important for us. And our Talk Justice Tuesday series has been great. That's our monthly series that we host the second Tuesday of each month. So I just thank you for everybody who's just been, just riding with us each month, for topics that are important for our community. And just keep joining us. So that's my take for tonight. I have to jump off because I actually, we're an hour behind. We're 5:30 in New Orleans, so I've got to do something this evening. But I thank you all, and follow our website. We don't have our chat open, but it is justiceforumpartnership.org, and follow us for more information about what we do as our partnership, our partner organization, Southern Poverty Law Center, CARE, Georgia as well. So thank you all.
Thank you. I do see, I don't know if you are able to answer that question, Megan.
Yeah, I'm looking at this now. So I don't know if anyone else can see if attendees can see the question box. So I'm just going to summarize this question really quick. S is saying that CARE doesn't have a history of representing Muslims who have faced material support cases in the last 24 years. Including some older ones in Georgia, and that the organizations usually contend those individuals publicly. So they're asking for some past examples and how CARE would be able to assist people facing cases in Georgia. I am afraid that my answer is going to be fairly limited by my context, which is that I have only been at CARE for about 3 years, and that CARE Georgia and CARE National operate quite separately. So I can only speak, at least off the cuff, to recent stuff happening in Georgia being done by the Georgia chapter. If you want to email me, my email's on the last slide. I can dig deeper to try to get some background here. But here's what I can say to what we're doing and can do in Georgia. Our legal team is small. We have 2 lawyers and a paralegal right now, and they have expertise in non-discrimination laws. We're not a criminal defense organization. So what happens a lot, to a significant amount of our cases, we get cases that are not in the scope of our expertise in terms of what our lawyers are actually going to handle. It would not be responsible of us to provide direct legal defense to someone facing a material support charge, because that's too far outside of the realm of expertise of our legal team. So for a case like material support or anything else that's sort of outside of our expertise, we refer out. We have a large network of volunteer attorneys in the community who are prepared to take on cases that we don't have the skills to take. So we have not dealt with any material support stuff in the time that I've been with CARE. So I'm afraid I can't speak to anything that's happened in the past. What I can tell you is that our process, if something were to happen tomorrow, would be to connect someone to a criminal defense attorney with the relevant expertise and understanding of the Muslim community. Most of the attorneys in our network are Muslim. And then I'm really glad you've raised this, and I'm going to take this back to our leadership team in Georgia to think more proactively about what we if there's anything else that we would want to put in place in advance so that we would be able to provide good care in these situations. I'm sorry I can't speak in more detail to this, but I hope that helps.
Thank you for that, Megan, and thank you, Nikki, for closing us out. If there are no more questions, we're going to stop the recording now, and thank you so much.